Hello and a very warm welcome viewers. You're watching this special presentation of Sansad TV with your host Kriti Mishra. India's criminal justice system is set for a complete overhaul. The government has introduced 3 key bills to replace colonial era codes with the objective of speeding up trials by laying down specific timelines, boosting rates of conviction by improving the quality of evidence and providing relief and protection to victims. So what are the key provisions in the bill? What are the major recommendations of the Parliamentary Committee on Home Affairs? Well, we've packed everything for you in this edition, so come along. India's criminal justice system has been predominantly shaped by laws and regulations inherited from the British colonial era. In the post-independence years, these legal foundations underwent alterations and amendments to align with the evolving requirements of modern times. The experience of 7 decades of Indian democracy calls for comprehensive review of our criminal laws, including the Code of Criminal Procedure, and adopt them in accordance with the contemporary needs and aspirations of the people of India. The pre-independence criminal laws were used by the British to protect their colonial interests, to rule the people and the country, and to maintain their authority and supremacy over India. There was a need for comprehensive review of the criminal laws, the Criminal Procedure Code, the Indian Penal Code, and the Indian Evidence Act, and adapt them according to the present-day needs and aspirations. In fact, Prime Minister of India also advocated for the need to revamp all the legislations enacted across all departments during the British era.
देश ने 1,500 से ज्यादा पुराने और अप्रासंगिक कानूनों को रद्द कर दिया है। इनमें से अनेक कानून तो गुलामी के समय से चले आ रहे हैं।
In accordance with the basic principles enshrined in the Constitution of India, it was proposed to bring about fundamental comprehensive changes in the framework of Indian criminal laws. With this objective in view, the existing Indian Penal Code of 1860, the Code of Criminal Procedure 1973, and the Indian Evidence Act 1872 would now be repealed and replaced by the Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023, and the Bharatiya Sakshi Bill 2023 respectively. The Home Affairs Minister introduced these 3 key bills in the Lok Sabha on 11th of August 2023.
ये तीनों कानूनों को रिप्लेस कर इनकी जगह जो 3 नए कानून बनेंगे, उनकी आत्मा होगी भारत के नागरिकों को संविधान प्रदत्त सारे अधिकार जो मिले हैं, इसकी सुरक्षा.
The main problems in present legal system are very complex. There's huge pendency of cases in the courts. There's low conviction rate, and the amount of fine prescribed in the laws is very less, from 10 rupees to 500. There's overcrowding of under-trial prisoners in prisons. There's very little use of modern technology in the legal system. And there's delay in investigation, pending hearing process, and delayed justice due to inadequate use of forensic evidence. The new bills seek to historically address the problems in the criminal justice system to strengthen law and order, simplify legal procedure, provide speedy justice, and adapt the criminal justice system with the technological advancements. Further, all the outdated references have been deleted in the proposed bills. These bills seek to create a legal structure which is citizen-centric and to secure life and liberty of citizens and adopt them in accordance with the contemporary needs and aspirations of the people. The Bharatiya Nyaya Sanhita 2023 repeals the Indian Penal Code 1860. Key changes proposed in the bill include sedition. IPC defines sedition as bringing or attempting to bring hatred or contempt or exciting disaffection towards the government. It is punishable with imprisonment term between 3 years and life imprisonment and or a fine. The bill removes this offence. It instead penalizes the following: exciting or attempting to excite secession, armed rebellion, or subversive activities, encouraging, feelings of separatist activities, or endangering sovereignty or unity and integrity of India. These offences may involve exchange of words or signs, electronic communication or use of financial means. These will be punishable with imprisonment of up to 7 years or life imprisonment and a fine. Terrorism. The bill defines terrorism as an act that intends to threaten the unity, integrity, and security of the country, to intimidate the general public or disturb public order. The bill also penalizes conspiring, organizing, or assisting in preparation of any terrorist act within an imprisonment term between 5 years and life imprisonment and a fine of at least 5 lakh rupees. Petty organized crime. The bill makes attempting or committing petty organized crime punishable with imprisonment between 1 and 7 years and a fine. Death penalty for gang rape of minor. IPC allows death penalty for gang rape of women below 12 years of age. The bill now allows death penalty for gang rape of women below 18 years of age. The Bharatiya Nagrik Suraksha Sanhita 2023 was introduced in the Lok Sabha on 11th of August. It repeals the Code of Criminal Procedure 1973. The code provides for procedure for arrest, prosecution and bail for offences under various acts, including the Indian Penal Code of 1860. The highlights of this bill are trials in electronic mode. The bill provides that all trials, inquiries and proceedings may be held in electronic mode. It also provides for the production of electronic communication devices likely to contain digital evidence for investigation, inquiry or trial. Electronic communication includes communication through devices such as mobiles, computers or telephone. Forensic investigation. The bill mandates forensic investigation for offences punishable with at least 7 years of imprisonment. Timelines for procedures. The bill prescribes timelines for various procedures. For instance, it requires medical practitioners who examine rape victims to submit their reports to the investigating officer within 7 days. Trial in absence of offender. The bill provides for conduct of trial and pronouncement of judgment in the absence of a proclaimed offender. This shall be done when such a person has absconded to evade trial and there is no immediate prospect of arresting him. The Bharatiya Sakshi Bill 2023 was introduced in the Lok Sabha on 11th of August. It repeals the Indian Evidence Act of 1872. The Act provides rules for the admissibility of evidence in legal proceedings. The highlights of Bharatiya Sakshi Bill are admissibility of electronic or digital records as evidence. The bill provides that electronic or digital records will have the same legal effect as paper records. It expands electronic records to include information stored in semiconductor memory or any communication devices like smartphones or laptops. Oral evidence. Under the Act, oral evidence includes statements made before courts by witness in relation to fact under inquiry. The bill adds any information given electronically to be considered as oral evidence. Secondary evidence. The bill expands secondary evidence to include oral and written admissions and the testimony of a person who has examined the document and is skilled in the examination of documents.
दस्तावेजों की परिभाषा का विस्तार कर इलेक्ट्रॉनिक या डिजिटल रिकॉर्ड, ईमेल, सर्वर लॉन्ग्स, कंप्यूटर, स्मार्टफोन, लैपटॉप, एसएमएस, वेबसाइट, लोकेशनल साक्ष्य, डिवाइस पर उपलब्ध मेल और मैसेजेस, ये सभी को कानूनी वैधता इस देता है, जिससे अदालतों के अंदर जो कागजों के ढेर लगते हैं, अंबार लगते हैं, वो समाप्त हो जाएंगे। अब हमने सर्च और जब्ती में वीडियोग्राफी को कंपलसरी करा है, जो अब वीडियोग्राफी केस का हिस्सा होगी। पुलिस द्वारा ऐसी रिकॉर्डिंग के बिना कोई भी चालान, चार्जशीट रखा जाएगा, वो वैध नहीं होगा। हमारा दोष सिद्धि का प्रमाण बहुत कम है। आज़ादी के 75 साल के बाद भी हम दोष सिद्ध नहीं कर पाते हैं। मान्यवर, इसीलिए फॉरेंसिक साइंस को हमने बहुत बढ़ावा देने का काम किया।
The need to reform and rationalize the Code of Criminal Procedure, as also the need to undertake a comprehensive review of the criminal justice system of India, has been expressed from several quarters from time to time. The Law Commission of India, in its various reports, has recommended several amendments in the criminal laws of the country. Rajya Sabha Chairman Jagdeep Dhankar referred these 3 bills to the department-related Parliamentary Standing Committee on Home Affairs on 18 August 2023 for submitting its report within 3 months. The committee, during its deliberations, held a total of 12 meetings spanning more than 45 hours. 19 domain experts were called before the committee to present their views on the bills. The experts invited to participate in the deliberations included senior advocates practicing in the Supreme Court and various high courts, renowned university professors, retired judges, Chairman of Law Commission of India, retired Director General of Police, and besides, the representations received from private individuals and organizations and members of Parliament and ex-members of Parliament were also examined by the committee. Some of the major observations and recommendations of the committee include: the text of all 3 bills is in English language and hence the proposed legislations are not in violation of provisions of Article 348 of Constitution. The Sanhita has widened the scope of definition of gender by including transgenders. For the first time, community service has been introduced as a punishment in Sanhita for petty offences. The committee appreciates the government for introducing death penalty as a punishment for the offence of gang rape on a woman below 18 years of age, which was not provided in the IPC. The committee has recommended the government to seek the opinion of Attorney General and Solicitor General of the country with regard to Clause 1012, which is apparently about mob lynching. The committee appreciates the government for enhancing the punishment under Clause 104 on causing death by negligence from 2 years to 7 years. However, the committee has recommended reducing this punishment to 5 years as the proposed punishment of 7 years is unreasonably long. The committee commends the addition of Offence of Terrorist Act in the Sanhita. The committee compliments the government in deleting the term sedition from criminal law by rephrasing it without compromising the security of the state. The committee has recommended the government to include Section 377 of IPC in the Sanhita. A recommendation has also been made to retain Section 497 of IPC on adultery in the Sanhita by making it gender neutral.
This is 75th year of our independence. Now, the salient features. The Bharatiya Nyaya Sanhita number of sections have been reduced from 511 to 356 and the chapters from 23 to 19. This is regarding Bharatiya Nyaya Sanhita, that is old Indian Penal Code. We have used the word Nyaya, not a dand, not a penal, because this is a democracy. We are giving justice, not a dand, not a penalty. 24 sections have been deleted from old Indian Penal Code, 22 have been added, and a large number of sections have been rearranged.
The existing laws stemming from the colonial era no longer represented the present-day dynamics and aspirations of Indian society. The existing laws have often been criticized for being outdated and not in tune with the present-day needs. The proposed Bharatiya Nyaya Sanhita seek to change the nature of law towards providing justice rather than punishment and would be a step forward to remove traces of colonial mindset. It was a mammoth task of drafting comprehensive amendments to the criminal laws and 4 years of intense discussions for making new laws that imbibe Indian thought process and the Indian soul. A comprehensive review of criminal justice system in our country was the need of the hour to bring it on par with the contemporary aspirations of the people of India. Well viewers, that's all I had for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.